Good day to you, wherever you may be in the world. My name is Gordon Harris from Gowling WLG. Welcome to the fourth in our webinar series, The Life Cycle of a Smart Idea, in which we take a fresh look at the world of intellectual property by tracing the choices, options, and steps which can occur during the lifetime of a smart idea, from the eureka moment to the steady stream of royalties or the big payoff and everything in between. Having covered the first choice, to patent or not to patent, the chain has passed through a look at trade secrets law in detail and an in-depth look at patenting strategy for life sciences patents. So today, we arrive in the exciting, fast-moving world of tech innovation. If you missed any of the earlier events and would like to see them on demand, you can go to our website, gowlingwlg.com, or goexcel.gowlingwlg.com, our exciting new platform, and find the recordings there. The world of tech patents has progressed so fast in the last 20 years that those of us involved have hardly had time to draw a breath. Not only has the technology been advancing at a phenomenal pace, but the law and practice underpinning the patenting of fast-moving tech has also evolved a whole new set of practices and a new vocabulary to go with it. We now talk with familiarity about standard essential patents, FRAND licensing terms, holdout, blockchain, and the Internet of Things, as if they'd always been there. But in fact, they're new, and they've all had an impact on patenting strategy in this area. And that is the topic for today's webinar. As usual, we have assembled a multi-talented and multinational team of experts from around our global offices to guide you through this turbulent and fast-moving world. So let me take a moment to introduce them to you. First, Alex Brodie. Alex is based in London. Her practice is focused on working with our clients to achieve their strategic goals in the context of multinational patent infringement and licensing disputes, usually in the standard essential patenting FRAND arena. She's co-chair of our global firm tech sector team and is responsible for the growth of that sector in our firm year on year. She secured a number of firsts in litigating patents on behalf of her clients, such as the first immediately enforceable injunction in a standard essential patent case post-trial, and the first finding of essentiality from the UK courts. Traveling over to Canada now, we have Kevin O'Neill. Kevin works in our Ottawa office, where he helps his clients draft and prosecute their patents. He works with a wide range of clients in the tech sector, from startups to large telcos. Kevin's technical experience has helped his clients get patents in difficult areas, including AI, cybersecurity, and data privacy. He is a registered patent agent in both Canada and the US. Back across the Atlantic to Germany for Jonathan Kernitz. Jonathan is a senior associate based in our Munich office who advises on intellectual property law with a strong focus on patent litigation. His wide range of experience includes patent disputes in various technical fields, including telecommunications, mechanics, and electrical and medical engineering. Through his work on numerous high-profile SEP FRAND cases, he has also developed an in-depth expertise in patent-related antitrust law and cross-border licensing negotiations. And finally to China, Jason Yang is a patent attorney in our Beijing office who is responsible for the prosecution of tech patents in China. Jason entered the IP world a decade ago and is now highly experienced in various patent-related work with a primary focus on the prosecution, drafting, and invalidity proceedings in the Chinese system. Jason has worked with clients and attorneys around the world, so he understands patent prosecution from a global perspective. So today I'm going to pose a series of questions to this great panel, and through their answers and conversation, we aim to give you a deeper understanding of the thinking which now underlies the strategic business of patenting in this area. We start from the premise that there has been a decision that patenting is the way forward. Sometimes in this area, the use of trade secrets protection can be preferable, or even copyright, and we've discussed these in a previous webinar. Today, we're assuming that we have moved past that choice and have decided to seek patent protection. So on that basis, I want to start at the beginning with the first issue in this area. Is what I want to protect patentable at all? And I'm going to start with Kevin and then go around the world on this one. So much of what is innovative in this area is effectively represented by software. So what is the position in your jurisdiction as regards patenting software? What is the potential scope of protection for software patents? And what are the key aspects to consider when drafting a software patent application? Why is patenting software maybe better than relying on copyright protection? So Kevin, get us started.
Sure, thanks, Gordon. In both Canada and the US, software is generally patentable. It can be protected as a method, a system or device, or as a computer-readable memory. Regardless of the ultimate scope of protection, software patents will protect the functionality of what is done compared to copyrights, which protects the actual code or how it's done. So software patents can offer significantly broader protection compared to copyright. Patenting software faces the same requirements as any technology. It must be useful, new, non-obvious or inventive, and it must be directed to statutory subject matter. The potential scope of software patents will depend largely on the technology and how crowded the area is. With more prior art in crowded fields, the claims will need to be narrower in order to overcome the novelty and obviousness hurdles, while in areas with relatively little relevant prior art, broader protection may be possible. The statutory subject matter requirement can be a major stumbling block for software-related patents. In both Canada and the US, abstract ideas, mathematical formulas, among other things, are prohibited from patenting. There are particular tests in both Canada and the US for determining if a claim is directed to statutory subject matter. Unfortunately, even with these tests, the question of whether or not a particular software is patentable is not clear-cut and has a lot of gray area. Working with startups over the years, I've tried to simplify that question of whether or not their new ideas are patentable, as they tend not to be interested in legal definitions or tests. I found a good question is, what is the underlying technology you've developed? What is your technical solution to the technical problem you face? Although in the US and Canada, an invention doesn't need to be a technical solution to a technical problem, I find in practice that this provides a good, simple, plain language understanding of what might be patentable. Have you developed some new underlying technology? As an example, let's say you've come up with a new piece of software for classifying obstacles as traversable or not. It may be particularly useful in autonomous or self-driving vehicles. If the underlying technology simply receives obstacle information, such as the height of the obstacle, and then determines if the vehicle can drive over it by comparing that height to the vehicle's clearance, this might not meet the statutory subject matter requirements, since the underlying technology is basically just a mental process of comparing the height to the vehicle clearance. In contrast, if the underlying technology is a new way of processing an image in order to segment that image and then quickly identify segments with potential obstacles, and then select an optimal algorithm for further classifying each of those optical segments, for example, as a rock or person, this could provide that underlying technology to overcome the statutory subject matter hurdle. Given the subtleties in whether or not software is patentable, I think it's important to work with an agent or draftsperson that has a good understanding of the technical areas you're working in, so that they can understand what it is that distinguishes your technology. Not only will this help in overcoming statutory subject matter concerns, it can also help with ensuring that your patent broadly protects that core nugget of technology instead of narrowly protecting a specific implementation.
Kevin, thanks very much indeed. That was really interesting and a lot of very detailed stuff in there. Thank you. Let's go to Germany now and hear from Jonathan. Jonathan, what have you got to say on this?
Thanks, Gordon. So I'll speak a little bit about the patentability of software in the EU and in Germany. And it is important to know that a program, a computer program as such, is excluded from patent protection. So in order to be patentable, the computer program must have a technical character. So this means that the computer program must produce a further technical effect when run on the computer. So to give you an example, a technical character is clearly there if the software, for example, controls a technical process. So think of a software in charge of controlling the anti-lock braking system of a car. To give you a counterexample, which is actually based on a recent decision by the Boards of Appeal, the European Patent Office, imagine a software recommending a shooting spot for a photo to be taken. Now that specific program allowed you to specify a search for images based on criteria like a building, a mountain, lake, waterfall, forest, etc. in a specific arrangement, and the software would then search for respective images where you could take a respective photo. And so although in vacation for some people the really most important thing is to take the perfect selfie back home. The EPO found that this is not a technical test, so there was no technical effect here. So I really think that the question that, that Kevin mentioned as a test question, whether the invention is a technical solution to a technical problem, makes absolute sense from an EU perspective as well. And it is actually much in line with the test question or legal standard that the German Federal Court of Justice, excuse me, uses in order to assess whether an invention only relates to a computer program as such. So what the Federal Court of Justice asks in this regard is whether the invention contains instructions which serve to solve a specific technical problem by technical means. So that's very close to the question that Kevin just raised. So when it comes to drafting a software patent, it is really crucial to get to the bottom of what is the specific technical effect and actually just write it down in the application. So this brings me to the last part of your question, Gordon, why patenting software is better than relying on copyright protection. As Kevin already explained, and it applies to the EU as well, copyright can protect the software code, but a patent can give you a conceptual protection, which means that by using multiple programming codes, it can be infringed.
Thanks very much, Jonathan. Right, Alex, obviously Jonathan's covered much of what's said about the EU there, but over to you anyway.
Gordon and Jonathan. The UK approach to patentability takes its cues from the EPC, and so all that Jonathan has just said applies equally in the UK. There may be nuances of application, but the theories and principles are the same. And other key jurisdictions will, for telco patents in particular, also take their cue from UK law. So these concepts feed through, and a good example of that is Indian patent law. You asked, Gordon, why patenting software is better than relying on copyright, and a couple of points on that. In the standards essential field, which you mentioned earlier in your introduction, well, frankly, patents are all that count. You've got to prove essentiality against the standard, and that positions you in terms of your brand licensing revenue. So the question of patents versus copyright in that field, I mean, really just doesn't arise. But more broadly, I mean, as we all know, it's really difficult to prove ownership and substance of copyright. It does protect the code, and so you have your first issue with your developer team. Now, are they baking in open source? Are they borrowing code from elsewhere? Are they importing code that they've already produced for somebody else? It's going to give you real issues with that. And secondly, even if you can prove substance ownership, you then have to prove infringement, because there's no infringement without copying. And so if you want to protect your invention, your inventive concept, there really is only one answer in my view, and that is your patent.
Thanks very much, Alex. That's very clear. Right, it is 9 o'clock in the evening or just gone in China. So thank you very much, Jason, for joining us. And let's hear what you have to say.
Thanks for the introduction. Chinese Patent Office used to be very strict on software patents, and software was usually allowed only as a method or virtual means plus function. About 2 years ago, the Patent Office changed the rules so that software can be protected in the form of a medium as well. This was actually a big step forward, in my opinion, because medium is a storage of a real product, such as a mobile phone or laptop or a real device that you can touch, meaning that it's easier for enforcement compared with a method or virtual means for which you might find hard to obtain the evidence. Kevin and Jonathan have mentioned that a technical problem and technical solution are very important for determining whether software is suitable to filing as a patent. I totally agree, because the same criteria also apply in China. As a patent attorney, I will not say a software invention is definitely patentable or not patentable, because it probably depends on how you drafted it. For example, finance-related software can be seen as a technical solution if the process relate, for example, aim to speed up the transaction. But if it appears as if it just deal with your money, then it's very probable that the patent office will refuse it because it's a non-patentable subject matter. But the good news is, based on my experience, the Chinese Patent Office is currently not inclined to reject a patent application purely because it's a non-patentable subject matter. Instead, examiners will still rely on prior research to challenge the novelty or inventiveness for a software patent. So at the end of the day, the two most important things you will need to bear in mind are first, whether the software is a technical solution that solves a technical problem, and then two, whether the software is new. Then speaking of Hong Kong, it doesn't really carry out a substantive examination themselves. Instead, it relies on three other patent offices for examination. That is EPO, IPO of UK, and the Patent Office of China. Then to register a patent in Hong Kong, one needs to have a patent granted by either of the three patent offices. Therefore, you don't really need to worry about software issues that will be raised in other jurisdictions. Lastly, although I'm not a Japanese patent attorney, I can share some of my experience about the general practice in Japan. Japan, in general, has a very open attitude toward software patents, as long as the invention is performed by a machine or hardware. Luckily, this requirement is usually met by software because software is designed to be used by physical device anyway. And under this standard, a business method coded into software will not have a problem in Japan.
Thanks very much, Jason. And that's very interesting, the liberality of the Japanese system there. So thank you very much, panel. We now have a better idea of what we can achieve with our patenting process. So let's take a first look at one of the big issues in this area, especially but not exclusively as regards patents involving connectivity and telecoms. And that is the question of patent pooling and the standards bodies. I'm going to start with Alex on this one and then go around the panel. It's common for there to be a proliferation of patents protecting inventions in the tech space. Why is this? And what is the impact of that on a strategy for pooling patents with the standards bodies or not? Is a mixed portfolio of pooled and unpooled patents preferable? Now, Alex has spent much of the last 15 years swimming in patent pools, so who better to take a broad strategic view of the whole issue to get us started? Alex, over to you.
Gordon. Well, I mean, to answer your first question, there are a number of patents simply because telco communications is invention rich. And if you stop and think about this, just in your own lives, the pace of change is just phenomenal. You know, it took between 2G launching and 4G launching on all of our phones and devices. That was just 17 years. I mean, that's less than the lifespan of a single patent. And think back to it, when you had your 2G phone, it was just text, no pictures, no music, no video, no online gaming, no Netflix, no ordering pizzas to the middle of the socially distanced gathering in your local park, nothing. You couldn't get on an app and order a taxi in London, Delhi, New York, Boston. When you stop and think about the level of innovation in just that one area, that's the answer to your question, Gordon, as to why there's so many patents. It's because there are so many inventions. And you're now seeing people working on the filings in 5G, on AI, and clients are now working on projects in, well, we're calling it 6G for want of anything better to call it at the moment, but it won't be that. But pulling back to any standardized industry, the difficulty is you need to be innovating ahead of the standard, obviously, otherwise the standard will invalidate you. And you want your innovations to form part of the standard and not be rendered obsolete through lack of adoption. So consequently, you need to be innovating across a really broad range of avenues, options, and possibilities, and then patenting each of those innovations that you've come up with. So I think that really is the answer as to why are there so many. And then your other question, Gordon, was focusing on pools and self-licensing. Frankly, I think that's just a pragmatism point, really. You're most likely to self-license if you can manage the size of your portfolio, if you're across the sector and its norms, you feel very confident in negotiating within that sector. But if your patents have suddenly started to cover a whole new use case, you know, for example, your communications patents in autonomous and self-driving vehicles, then you may find that you wish to put those patents or the use of those patents into a pool to license because you're not across that sector, you don't understand its norms, you don't have the relationships, and maybe your licensing team is already stretched to the limits in dealing with what it's already dealing with. So I think pool or not pool is largely a pragmatic decision.
Thanks very much, Alex. As we hoped for, a good overview to get us started. So, Kevin, let's move over to you and to look at the position in Canada and the US.
As Alex mentioned, the pace of advancement in tech gives rise to the large number of patents. I think tied to that, and this is particular to the US, is the use of continuation applications. A continuation application is very similar to what the name implies. It's another application, typically filed after allowance of the parent, that continues on with a new set of claims. There are various uses for them. For example, startups will often want to get patents issued quickly for investment and marketing purposes. Continuations allow that startup to accept narrower claims quickly in order to increase the number of issued patents while still pursuing a broader scope of protection in the continuation application. The continuations can also be filed to keep a pending application alive. While the claims of an issued patent are more or less set in stone, the claims of a continuation application can be tailored based on changing circumstances, such as a competitor's changing product or possibly a change in the focus of your business. For standard essential patents, continuations can be particularly useful since the standard may not be completed when your initial patent is allowed. By maintaining the pending application, you can amend your claims within the bounds of your description to be more closely aligned with the final standard, which may make the difference between having a standard essential patent or not. When it comes to deciding whether to have a patent declared as essential to the standard, it will depend on a number of factors, including whether or not we're considering an issued patent with those set in stone claims that can be analyzed to determine if they are in fact essential to the standard, or are we talking about an application with claims that may yet be amended during prosecution so that they no longer cover the standard? Further, is the company part of the standard setting organization such that they're under an obligation to declare their patents and applications that may cover the standard? Any portfolio is necessarily going to be constrained to what has actually been invented, but I think in an ideal world, at least from the patentee's point of view, a portfolio would include both standard essential patents as well as patents that cover practical or nice to have features that are not part of the particular standard. However, if all you've invented is technology that is not essential to the standard, then of course, that is the portfolio we'll have. In addition to standard essential patents, which can be basically a pool of patents that are required to implement the standard, it is possible to have patent pools that are not for the particular standard. Whether or not to include your patents in such a pool face similar considerations as standard essential patents. A pool may provide a relatively easy royalty stream since someone else is administering the licensing. However, that royalty may be smaller than you could achieve if you were willing to negotiate each individual license. As with so many decisions in patenting, the right decision will be dependent upon the particular facts facing the business.
Thanks very much, Kevin. It sounds as though what you're saying is similar to Alex there, that bandwidth may play quite a big part in this
Absolutely.
decision. Yeah. Jason, let's hear about the position in China.
Yeah, thanks. In China, I experienced that the wording and expression of a standard essential patent can be important. For example, when you draft a patent that might be standard essential, the technology usually not mature at the time, and you don't even know what terms or expressions will be used in the standard. As a result, the difference between the claim language and the standard language can cause problems during negotiations and litigations. In addition to the continuation approach mentioned by Kevin, in China, the applicant can postpone the examination by 1 to 3 years. So there's enough time to change the expression before it's granted, and the claims will look more closer to the standards. On the other hand, however, a potential licensee should also be aware that an SEP might have been changed drastically during the prosecution in order to meet the standard. And I would say some of the content is likely not supported by the initial disclosure. This is something you'll need to pay attention to in China and in Europe, because new matter can be crucial in these places. Therefore, if you're a potential licensee and try to challenge the SEP, my suggestion is always to examine the prosecution history to see if there's a shift of expression. Chinese companies, on the other hand, have divided views on pools and standards. Big names such as Huawei and ZTE rank top as we know it in terms of the number of SEPs, but most domestic companies are more defensive than offensive. A typical Chinese company tends to spontaneously team up with other players on the market to set up the patent pools, but they're usually not aggressive in suing others.
Thanks very much indeed, Jason. That's really interesting perspective from China. But of course, going forward, the UK will not be part of the European Union, and some of this stuff does relate to EU antitrust law. So let's hear from Jonathan in Munich on what is happening in the EU.
Thanks, Gordon. So I think Kevin, Alex, and Jason have already covered the most important aspects. But I would like to add one brief additional point relating to antitrust law, as you already mentioned. So when a portfolio consists of SEPs and non-SEPs, you should be aware of the issue of potential unlawful bundling, which can appear in particular in SEP litigation. As you know, and we'll talk about this in a bit more detail in a minute, if an SEP is asserted, the SEP owner is usually required to offer a license to the asserted SEP in order to be granted a claim for injunctive relief. In this case, the question obviously appears how the offered portfolio should be structured. So should it only include the SEP in suit? Should it include all SEPs? Should it include all SEPs and non-SEPs of the patent owner? And when considering this question, it's important to remember that from an antitrust law perspective, there can be an issue should a court get the impression that the pressure by asserting the SEP is used to also license other patents. So in particular, when it comes to when the other patents cover other technologies that might not necessarily be infringed by the patent user. And the case law is still in flux in this respect, and there are different opinions in different jurisdictions. But as a general tip, when it comes to structuring the portfolio, it should really always make sense from a commercial perspective for both sides. And it should be in line with industry practice, and in particular in litigation, it should be counter-checked by a legal expert from the relevant jurisdiction in order to avoid these issues.
Thanks very much indeed, Jonathan. So, as we have heard, the big implication of getting patents accepted as being essential and added to a pool is the issue of agreeing license terms which are fair, reasonable, and non-discriminatory, FRAND, the expression we come to use. This issue is giving rise to complex litigation all around the world, with different jurisdictions taking a different approach to the scope of what they think they can order in terms of FRAND license terms. We're still awaiting the definitive answer in the UK from the Supreme Court in Unwired Planet and Huawei, but so far the UK has taken an expansive view, and we'll hear more of that from Alex shortly. But first of all, let's have a look around the world to see how other countries are dealing with this. And we're going to start in China with Jason. So what is the position in China in terms of the court's rulings on FRAND terms? Are they prepared to look outside China and make a broader order, or are they tying their decisions to the Chinese market alone?
Yes, Gordon, it's relatively new. In the year of 2018, Guangdong High Court issued the working guidelines on the trial of the SEP disputes. Interestingly, this guideline has incorporated rules established in a number of SEP-related cases worldwide, including such as Huawei versus ZTE in Europe, Unwired Planet versus Huawei, that you know it, in the UK, Motorola versus Microsoft in the US, as well as some other cases. According to the guidelines, when requested to decide whether to grant injunction to a SEP holder, a court should evaluate who is at fault during licensing negotiations. It says that only when the SEP implementers is at fault, the injunction might be granted. The guidelines also listed some examples that may be deemed as a violating FRAND for the SEP holder or implementers. You may find the guidelines from the internet, and it's very detailed, so you can have an idea as to whether a particular conduct is at fault. More importantly, the guideline has defined some examples to decide a FRAND rate, including most comparable licenses and market value analysis. In terms of market value analysis, a top-down approach is required to be applied. Again, at the US court rules in TCL versus Ericsson, the guideline also supports application of a top-down approach by referring to the claimed cumulative royalty rates as declared by the industry players. The guidelines explicitly only apply to SCP cases in the telecom industry, but at the same time mention that they can be used by reference in other fields as well. Therefore, it's possible that the guidelines can be valuable beyond the telecom sector itself. The current status of the guidelines is unknown due to the recent reorganization of the IP courts in China, such that all IP appeals no longer go to the Guangdong court, but the guidelines remain as an instructive document regarding how the Chinese courts are likely to approach this kind of disputes. It's also interesting that although Chinese courts are relatively independently making decisions, it can be seen that they are willing to give out guidelines or interpretations by hitting important cases around the world.
Thanks very much indeed. And that is genuinely interesting, isn't it, that the Chinese courts will look outside China to take, in the same way that maybe the UK and American courts have looked at each other, or UK courts and German courts have looked at each other. It's interesting that the Chinese are doing that now. Talking of Germany, Jonathan.
Thank you. So in Germany, we've already had a lot of FRAND decisions, and the prevailing view is that FRAND is actually a legal defense against a claim for injunctive relief, and that legal defense is based on antitrust law, namely an alleged abuse of a market dominant position. The reason for this is that the relevant European landmark decision, Huawei versus ZTE, actually deals with the interpretation of a European antitrust law provision, namely with the question of whether bringing an action for infringement based on an SEP seeking a claim for injunctive relief is an abuse of a market dominant position. And it is worth noting, though, that in the Huawei case, dominance was already found. So that was undisputed in the national decision, and the court didn't have to deal with this question. So whether the right approach to dominance was taken is up to national litigation, basically. Now, what's the background of the possible abuse? By enforcing a standard essential patent, it is obviously possible to actually exclude the patent user from a relevant market, because it is not possible to distribute standard compliant products without using all truly standard essential patents. So therefore, an SEP may confer a market dominant position, and consequently, it might be an abuse of a market dominant position to enforce a standard essential patent. And following this interpretation, German courts, in most of the FRAND cases, as a very first step, assess whether the SEP confers a market dominant position. And interestingly, this is not automatically the case for each SEP. So for example, if the SEP only covers an optional feature that can be switched off easily without affecting the marketability of the product, then there might not be a market dominant position. So in this case, in Germany, it can be possible for the SEP owner to get a quick injunction based on that SEP without going through this FRAND process. However, if there is a market dominant position, then the court will assess whether there's an abuse of that position. And in general, one has to say that during the last couple of years, and most of the decision we've seen, German courts have interpreted and applied the Huawei ZTE decision in a rather patent user-friendly way. I've personally been involved in a lot of FRAND litigation on both sides, and in most of the cases, it has really been an uphill battle for the SEP owner, which, depending, of course, whether you're the plaintiff or defendant, can be, of course, a good or bad thing. But in the end of the day, I really think that the industry is always best served with a balanced approach. Recently, we've seen significant changes towards a more SEP owner-friendly approach. Notably, the German Federal Court of Justice has recently rendered its very first FRAND decision in the case of Sisvel versus Haier. And from what we know so far, the court has significantly raised the bar for implementers to express the willingness to take a license. Unfortunately, the written judgment is not available yet, but it will probably be within the next couple of days. I'll check right after the webinar. And of course, once it is published, we'll make sure to publish an English summary on our website.
Thanks very much indeed, Jonathan. Right, Kevin, let's hear about the position in Canada and the USA.
So in Canada, there really haven't been any court decisions surrounding FRAND licensing terms. In the US, there have been a number of decisions and guidelines that provide, similar to what Jonathan noted, a somewhat more friendly environment for SEP owners. The USPTO stated in a recent policy statement that standard essential patents should be treated the same as any other patents, and that when licensing negotiations fail, appropriate remedies should be available to the owners, even for standard essential patents. What are the remedies available? They include monetary awards from the courts or juries that can be rather substantial. As Jason mentioned, these can be based on a top-down approach that attempts to determine the size of the market and then the contribution the patent makes to that market, or a bottom-up approach that looks to licenses for comparable technologies. These approaches aren't mutually exclusive, and both factors can and are considered. Other remedies can include injunctions preventing the sale of the infringing product, or possibly an ITC ruling barring the importation of the product in the US. If the licensing negotiations fail, litigation may be the only option remaining. At that point, I think it's worthwhile to step back and consider the litigation, not just from a US or single jurisdiction's perspective, but from a global point of view on how best to achieve your litigation goals.
Thanks very much indeed, Kevin. Now, if there's one jurisdiction where we know the courts are not shy of grasping this particular nettle and dealing with it, that is the UK. So let's hear from Alex about how things have evolved there.
Thanks, Gordon. Well, when you're trying to decide where to litigate FRAND, I think you need to just step back a bit and think, well, what is FRAND normally? And what I'd suggest is that in arm's length negotiations, it's clear that most licensors and licensees who actually strike a deal tend almost exclusively to strike a worldwide license. They don't license territory by territory for very obvious pragmatic and cost-effective reasons. And they also tend to insist on confidentiality in those negotiations. Nobody makes their negotiations and resulting license public unless they absolutely have to. So given that the norm is worldwide and confidential, it seems to me that actually international arbitration is your obvious best answer to providing a neutral determination by a third party, which is most akin to normal business practice. As a team of litigators here at Gowling, we're very fortunate to be able to work with our in-house arbitration team, and we've been able to bring home some really successful deals for our clients, both in this sector area and other ones. And I genuinely believe it is the best answer. But as we all know, you can't force someone to arbitrate if they don't want to, and nor will a court force them to. So if we're litigating, we've got to work to align our litigation strategy with our clients' commercial goals. And to do that, you need to work as one team internationally to achieve a coherent game plan. At present, the only court in the world which will determine FRAND on a worldwide basis absent consent from both parties is the UK, and that arises from the Unwired Planet decision at the High Court, which was affirmed by the Court of Appeal. That case has gone on appeal to the Supreme Court in the UK. It was heard in October 19, and we're awaiting the decision literally any moment. And the reason why the UK's done this, as opposed to other courts, such as those in the US or France or Germany or China, is it's just a basic jurisprudential point, which is that we're a common law jurisdiction, and therefore our judges have the discretion to craft injunctive relief to provide for an equitable outcome in their view. So accordingly, the injunction you'd normally get for patent infringement, which is to throw you off the market, is varied because of the FRAND commitment to say to the defendant, hey, you've infringed an essential and valid patent, you're coming off market unless you would like to take a FRAND license. And given you lot can't decide what that is, the court will decide for you. So what is your choice? And I think it's really important to remember this is the defendant's choice. So if you want a global FRAND license in the context where you don't think the defendant will elect the injunction, the UK is currently the only jurisdiction to go to. But you'll probably want to consider other jurisdictions as well in your strategy in order to better protect yourself from a forum race. So, for example, where do you want to be in the US? Which district court? Would ITC proceedings help you? Can you create additional pressure by way of an infringement finding in Germany? If you're a defendant, what about a rate setting case in China? What about a series of invalidity attacks in a key economic market such as China? And do consider other jurisdictions. We've seen a lot of interest in India recently here because of their prelim injunctions converting to preliminary security payments of sizable amounts. We've seen recent cases actually brought by Nokia, Ericsson, and Philips, and with some degree of success in driving a license pre-trial. The pools also are in active litigation, and I think it's notable that Sysvel and HEVC Advance are both in current litigation before the UK courts.
Thanks very much, Alex, and that makes that very clear indeed, of just how strong the UK position is in this area at the moment. So thank you very much, panel, for that. Now, of course, these days, everything is a computer. Your car is connected to your doorbell, which is connected to your fridge, which is connected to your supermarket order. The Internet of Things is slowly but surely encroaching on every aspect of life. Add to that financial transactions via blockchain and wearable minute-by-minute diagnostic information through watches and armbands, and the computerization of our lives is well, it's almost complete. So what are the implications of all of this for patenting, strategy, and practice? Before I just ask that question, on the subject of questions, can I just say to the audience today that there is a Q&A button at the bottom of the screen, and if you want to raise a question with the panel, please do feel free to type it on there, and we'll try to find time to get to some of them at the end if we can. So the question arising in relation to the Internet of Things, let's start with Jonathan and then go around the panel. Can you take us through the Internet of Things and Industry 4.0 and explain the implications for global patenting strategy? How must the motor industry adapt to the connectivity of cars, for example? Jonathan, over to you.
Sure. So the Internet of Things, as you already mentioned, refers to the really billions of everyday devices that are connected with the internet and are able to collect and share data. So just think of your smartphone or your tablet that is able to interact with more and more devices at home, like your TV and maybe even your oven or your fridge. You've surely heard about the term smart home in this respect. So if you're at work and you can't remember if you still have any fresh milk left in your fridge, just take a look using your smartphone that is connected with the food can inside your fridge. So this is easily possible already today, and more devices will join the Internet of Things, and the applications will become more and more complex. Now, Industry 4.0 refers to the fourth industrial revolution, where traditional manufacturing and industrial practices use the latest smart technologies, including improved connectivity, communication, self-monitoring of machines, etc. In this development, obviously, standardization becomes even more important, because now your fridge and your smartphone might be using the same Wi-Fi or mobile technology, because they need to be able to communicate. And all of this changes the patent landscape drastically. Digital communication and computer technology have become the new leading fields in patent applications. But it also changes litigation practice, which today involves more and more industry. So we've seen the smartphone patent wars in the last 10 years, and we've recently seen the start of the automotive patent wars as well. And in the future, we will surely see other industries moving into the focus of SEP, honors request for royalties. So let me get to the last part of your question, Gordon. How should the motor industry adapt to the connectivity of cars? Well, we could surely talk about this the whole webinar, but at the moment, I think it's important to understand and just accept that there are still a lot of open questions that need to be resolved. For example, what is the right license space in order to calculate an appropriate royalty payment for the use of, for example, 3G technology in a car? Should it be calculated based on a percentage of the sales price of the car, a fixed price based on the 3G chipset? Is there a prior obligation maybe to try to license a supplier before the car manufacturer may be held liable for patent infringement? And there's a lot of sensitivity regarding these issues in Germany at the moment. And you might have heard that very recently, a couple of days ago, the German Federal Cartel Office has actually intervened in one of the big cases going on in Germany at the moment, raising concerns in particular regarding the question of who in a supply chain should be the right one to take a brand license for the respective technology. So there's really a lot going on in this field at the moment. And our global patent team is always monitoring these developments very carefully, not only in Germany, but everywhere else in the world, to just be ready to come up with the best strategy for our clients at any given time.
Thanks very much indeed, Jonathan. It's a very comprehensive answer, and very grateful to you for that. Right, Kevin, can you give us a sort of patent attorney's eye view of this, the opportunities, but also maybe the threats and concerns of the pace of innovation?
From someone who drafts and prosecutes patents, the high pace of innovation is great. It means there's lots of innovations to patent. However, broadly speaking, this can mean that the value of an individual patent is decreased, where in the past or in other technology areas, a single patent could cover an entire product. Today's high-tech products may be covered by thousands, if not more, of individual patents. And so the value of these individual patents can be diluted. A particular challenge for drafting patents, given the rapid pace of development, is providing patents that are not relevant not only to today's technology, but that will remain relevant in the future. I think I touched on it previously, but focusing your application on that core nugget of your invention or the underlying technology you've developed will hopefully provide a claim scope that will apply not only to today's specific embodiments, but also to different applications in the future. Another challenge companies will face is dealing with third-party patents. While patent pools can help provide a space an implementer or developer may be free to innovate within, there is no guarantee that there aren't other patents in that area. Given the large number of patents, it can be difficult to completely avoid patent infringement in the high-tech space when developing a new product. One of the suggestions I give to clients is don't bring possible future problems up sooner in your timeline unnecessarily. Patent infringement may eventually be an issue, but don't let it stop you from developing today. Of course, this isn't to say turn a blind eye. You don't want to redevelop the wheel, but you can develop your own technology and patents today that can be used in cross-licensing and mitigating possible patent disputes in the future.
Thanks very much indeed, Kevin. Alex, let's hear from you on this area.
Thank you. So the new technology, I don't think, is really the issue. The bigger issue for us, whether acting as patentee or implementer, I think, is the explosion of use cases. I mean, how do you, as a patentee, effectively maximize the value of your asset base? How do you approach the norms of a new industry? How do you price and evaluate your patents in that new industry? And as an implementer, how do you assess the patent portfolios that may affect your new route to market, especially when they may be coming from sectors that you haven't anticipated, you don't keep an eye on? And how do you price and evaluate your new product and service effectively to take into account any royalty burden you're about to encounter? And how do you patent effectively to protect your invention across this multiplicity of use cases? I mean, how can you draft a claim set that will work in all eventualities? So I think it's not necessarily the new technology that's the issue, it's the new use cases that are the issue. And I mean, Jonathan quite rightly outlined a number of them, as you did yourself. I mean, personally a little worried about food cans. I think my consumption of chocolate in my fridge is entirely my own business. I do not want that on the Internet of Things. There we go. You know, and then there is AI, which is the focus of one of our forthcoming seminars run by, you know, our AI team led by Matt Harvey and Neyman Taki. I mean, can you patent it? And what will it do to your patents if you've used it as the inventor? Is it all data? And how do you protect data in any event? I know I'm answering a question by just littering more questions in front of the panel and our audience. But you do need to stop and think about this one. It's going to be hard.
I think you're absolutely right, and I'm sure Jason's delighted to be going next with all those questions hanging in the air. So Jason, give us another patent attorney's view with specific reference to some drafting suggestions maybe to cope with the global perspective and different patent office views, some of these new technologies.
Yeah, as a drafter, the hardest part of drafting patents for filing globally is that the different patent offices will treat things differently. Some patent offices are more willing to see patent applications in these newer fields, while others might be more conservative. For example, artificial intelligence has been a hot topic in recent years in China, and the Chinese patent office generally place less obstacles when it comes to abstract ideas. Even if the invention mainly relates to algorithm improvements only. However, It doesn't mean the applicant should be or would be treated the same way in another jurisdiction. Similarly, it's usually okay to put mathematical equations in claims in some jurisdictions, but for example, an examiner in the U.S. Can probably reject the application entirely simply because it will be seen as a mathematical method. For these newer technologies, a lot of details about algorithms, software, and modeling are often inevitable. So it's very important for us patent attorneys to generalize the concept in the right way and draft the claims suitable for most patent offices. All of our patent attorneys are experienced in drafting patents for most patent offices, so you're more than welcome to come to us regarding how your technology can be protected.
Thanks very much indeed, Jason. That's a good point to finish on. So thank you very much indeed to the panel for where we've got to so far. There we see how the tech and engineering sectors are moving ever closer, along with the finance and health sectors. Everything is tech these days. I always like to close these events now by giving the panel a chance to make one key point that is relevant to their own jurisdiction, a kind of takeaway message for those who are looking at truly global coverage for their tech patent portfolio. So let's do that. Let's run around the panel here and give them a chance to make one key point from their own jurisdiction. Let's start in Canada with Kevin.
Oh, in Canada and the US, and listening to my colleagues today with around the world more broadly, I think with careful consideration and drafting at the outset, it's possible to protect software, whether it's AI, blockchain, or any other buzzword. Unless you're buying them, your patents are going to be dictated by what you develop. So if you're developing new products or technology, have some process in place for evaluating whether those new ideas are actually worth patenting. Not all of the ideas are going to be worthy of a patent application, and not all the applications will become patents, and not all of those patents will be monetized. So you want to ensure your funnel opening is large enough to consider all possible ideas, good and bad. You want to ensure that you capture the good idea that ends up being the money-making patent.
Thanks very much, Kevin. Alex, what's the UK's key point?
The UK is creative with its relief. It will take a pragmatic and commercial approach to justice and is flexible. I think we're also blessed with a truly expert, neutral set of patent judges. So the venue works well, whether you're claimant or defendant. But in a way, this is a bit misleading, Gordon, because the best strategy is multifaceted. And we're well placed to field a team with great bench strength in complex multinational patent litigation. And frankly, that's what you need in this area.
Thanks very much, Alex. And I think it certainly is true to say that when you're sitting down with a potential patent in this area, you know, thinking internationally is absolutely key. It's crucial to the strategy. On which subject? Let's go to Germany and hear from Jonathan.
Yeah, so in Germany, I think the point to remember is that there have been a lot of highly interesting and important developments with respect to FRAND lately. Including a first judgment by the highest court, which might harmonize the interpretation of the Huawei ZTE decision in Germany, at least to some extent. So if you're involved in SEP litigation in Germany or are considering Germany as a forum, keep that in mind, make sure to stay in the loop. I'm happy to help with that.
Thanks very much indeed, Jonathan. So let Jason have the last word on this one from China. Jason, what is your takeaway point from China?
Yeah, in China, almost all high-tech patent applications can be patented if they're drafted correctly. And in general, the patent office welcomes newer technologies. However, it's a market very different from Europe or North America. So the filing strategy and the patent portfolio in China need to be examined differently as well. In addition, this is a unique point. Unlike most other countries, Chinese patents needs to be maintained annually. This means the fees will increase with time and it can be substantial for the last few years. Therefore, I would suggest that you should evaluate your patent portfolio in China frequently to see whether some of the patents should be kept.
Thanks very much indeed. And I think, to be honest, that's good advice wherever you are in the world. But thank you very much, Jason, for that. Now then, we actually do have a bit of time to consider some of the questions. So if you'll bear with me a moment, I'm going to peer downwards at my screen and see what we've got for our audience. Okay. So yeah, somebody's asking here, you've talked about the issue of statutory subject matter with regard to software patents. Are there any other concerns you see in drafting these types of patents? Kevin?
Sure. I think one of the issues with drafting software-related patents, is, in addition to what we discussed today, is with regard to getting the right level of detail to ensure that there's the support you need. You want to make sure that you're not so broad that you're just giving an abstract description of what you've done, and you don't want so much detail that you're providing your actual code base. I think what you do want is multiple different levels of sort of abstraction down to a detail level that's possibly, you know, at least for that, again, going back to that core nugget of your technology, if it's appropriate, that you have some pseudocode description or something along those lines to provide that really detailed support. So I think that's one of the bigger issues for drafting software patents.
Thanks very much indeed. A very interesting question here from the audience. We discussed the number of patents in the mobile phone space. Does this make it almost impossible to economically review them? So how does one deal with the cost of reviewing a standard essential patent or other portfolio of, say, 200 patents? I mean, that's crying out for Alex.
Thanks. Yeah, it's really hard. If you were going to take each individual patent, subject it to unique individual assessment, and then try and collate the results of a 200 patent portfolio, that would take you a lot of time and cost, and I think is simply not practical. So the way we would normally approach this is either to, if you're the patentee side of this debate, you will probably have a good understanding of the patents that you think are particularly significant, and you might take a look at those. You will probably, whether you're patentee or defendant, be taking a look at the portfolio in the context of the wider portfolio that would come to bear on a product, so the portfolios of third parties. And in that respect, there are a number of really good data sources out there from third-party assessors who have looked at the royalty stack, looked at the share of the stack attributable to any given patent owner. And by consulting 2 or 3 of these, you can start to get a good feel for where you are in terms of, I've heard it referred to by various other people as a zip code or a postcode of the royalty range. So you know roughly where you're at. You might know exactly which house you're in, but you know roughly where you're at.
That's great. Thank you very much indeed, Alex. Another question here. How do patents in a growing digital world affect the geographical scope of patent protection and licensing? Jonathan, let's share it around. You go next.
All right. So I think Alex has already explained that a global license, a worldwide license, is already the standard, in particular in that field. And if you think about software patents, I mean, those kind of things don't know any borders. So you can download software anywhere in the world. So the importance of a wider patent protection and global licenses will get even more important in the future, which stresses the point that we've discussed also, that it's really important to work with an international team and to have an international approach from the beginning.
Thanks very much indeed. Sorry?
I was going to say, I think as well, maybe the question's directed to a consideration of economic markets, because if you're looking at patent protection and licensing, you clearly want good coverage in significant economic markets, and that might be the market of manufacture of the products in question, or it might be the key sales markets of the products in question. So I think a good understanding of market share and economics of individual jurisdictions will help with that decision-making process.
Thanks very much indeed, Alex. That's a useful contribution. I've got one more question, which is really my own to a certain extent. As many people know here, I've been involved in work in China for a long time. And one of the things that we used a great deal there, in addition to full patents, were utility models. So Jason, can you just touch on the question of utility models, and of which there are many, many filed in China each year, and just explain a little bit about how that system works?
Yeah, actually, it's the utility model is not unique in China. The Chinese patent office actually learned the utility model from Germany. It protects new structures or configurations of a product, but doesn't allow methods. The good thing about the utility model is that it doesn't need a substantive examination and can be granted very quickly. If you only want to invest a little in China for your IP, I think utility model is a good choice, and here's why. Because there are many, in my experience, there are many foreign clients working with Chinese manufacturers to make their products in China. But unfortunately, I know many of them do not register their IP in China at all because they think they don't want to sue in China because of time-consuming work. But their Chinese partners probably will secretly file utility models with clients' product designs and eventually come back to and sue the client if the relationship breaks up. So my suggestion is, even if you don't want to sue others in China and just want to make your products manufactured there, you really need to think about it to file utility models as early as possible so that at least you have something on hand to defend when necessary.
Thanks very much indeed. And that's very interesting, the notion of using utility models as a defense mechanism effectively against a potential dispute with a manufacturer in China. Right. Well, thanks to everyone who has attended this event today. We really appreciate your interest, and we hope we've been able to give you some real food for thought on this remarkable and fast-moving topic. I've got a few takeaway messages of my own. Tech patents are everywhere. And from my litigator's perspective, you need to have eyes in the back of your head, or to put it more in relevant terms, a really good global searching system, because you never know where there might be a patent lying in wait. Conversely, you never imagine that your software-based invention is not patentable. There are experts out there who can find that technical effect and get a patent over the line. Another message from today is that the previously evolving patent systems have evolved. Alex talked about India, and we've heard direct from Jason about China, and the Chinese system works as well and effectively as most others. It would be penny wise and pound foolish, as we say here in the UK, to ignore the patenting options in China. Right, in the next webinar in this series in 2 weeks' time, we're returning to the world of trade secrets and a lot more besides. Moving from the current format, we're taking a scenario-based look at the pursuit of a trade secrets thief around the world to show what tricks are available to catch a thief, as they say, in various jurisdictions and destinations. So look out for the invitation for that one, which will be coming shortly. In the meantime, a recording of today's event will be appearing on our website and at goexcel.gowlingwlg.com very shortly, if you would like to watch again, or perhaps more relevantly, share it with your colleagues. So thank you once again for your very kind attention today. We look forward to seeing you again at one of our next events in this series, and this broadcast will close automatically in just a few moments. Thank you very much indeed.